Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blanears. We hope you're having a great summer. By the time you are seeing this recording, we're recording July 17th. It'll probably be early August. We hope that you have had a great summer, enjoyed time out in the sun with friends and family, and maybe you're getting back to your desk, dusting off some work projects, and maybe even cracking open a compliance checklist. And to that, we are digging in to LCA compliance. So maybe if it's not already on your compliance checklist, to add it. With that, we'll dive right in. So, as we all know, LCA stands for Labor Condition Application, and the LCA is an underlying attestation that is part of the H-1B and E-3 visa applications. Now, some of those attestations include the employer attesting to pay the foreign national worker a prevailing wage. So the prevailing wage meaning the floor for what it is required to pay the foreign national employee based on the occupation, the wage level, and the area of intended employment. So let me break that down. The Department of Labor has a wage library for every coded occupation. And within those occupations, there are level wages 1 through 4 based on the minimum requirements for the position. So, for example, an entry level position would be a level 1, where a senior contributor in that occupation would be a level 4. And the Department of Labor hosts these wages for every area of intended employment based on the metropolitan statistical area in the United States. The intention behind this attestation is that the employer is attesting to pay the foreign national worker minimum wage so as to not depress the wages of U.S. workers. And as we know, under the Trump administration, the protection of the U.S. worker is at the forefront of the priorities for this administration. So the LCA is an important one and is not just a file it and forget it attestation. So that's why we're going to be talking about some ways to be checking in on your compliance and to be running audit reports. One thing to think about, again, from the attestation is how are you posting? Now, in a remote or hybrid workforce, we are recommending our companies or the employers we support post the notice of filing on an intranet. So, this is another attestation as part of the LCA filing that before the employer can file the LCA with the Department of Labor, it is required to post a notice of filing summarizing the position that the company is sponsoring and summarizing the wage or the wage range that it is offering the sponsored foreign national. Now, the posting can happen on the work site, so in the lunchroom bulletin boards, or on an intranet. Now, there are some more complicated posting requirements if you are sponsoring a consultant who will be on site at outside client locations. So, definitely look into that a little more. If you are supporting or sponsoring foreign nationals who will be serving as consultants at various client locations, there's some additional rules there. But generally speaking, we recommend for our companies supporting these LCAs to post on an intranet. Now, if you don't know what an intranet is or your company doesn't have one, give your immigration attorney a call so that they can walk you through what this enhancement would look like and looping in the right stakeholders within your company to get that set up for you. Again, the intranet is a huge benefit for these LCA filings for specifically how to post to alleviate the burden because you, as the global mobility leader, may be working remotely and can't walk into a work site to post on a bulletin board, and you may not want to be relying on on-site employees to make sure the postings are compliant. So those are the two sort of key components, the notice of filing posting and the attestation to the wages that are the general requirements that you need to be aware of for the LCA. Now, how are you testing compliance? So, sort of moving into what's going to be on your compliance checklist. How are you measuring whether your organization is in compliance? Well, the LCA forms into a public access file, and the public access file is something that the Department of Homeland Security or anyone lodging a complaint can ask to see. So it is public information that can be requested. And the public access file, by its very name, public, Should be summarizing that the company has completed the required posting. So it has that like posting notice that the employer confirms that the posting has been up for 10 consecutive business days. It has a summary of the benefits offered to the foreign national employee, and then it also has the signed certified LCA in it. Now, back in the day when I first started practicing as part of, the standard work process, our team as the legal team would mail a partially compiled public access file to the employer. So there may be some teams out there that still receive a hard copy public access file. So if you're a global mobility leader stepping into the role, you might want to put on your compliance checklist, see if there are any paper public access files to track down and scan and make those electric. Nowadays, these are being delivered or partially delivered in an electric form. You also want to check in with counsel with how you all are partnering on compiling the public access files. I think some legal teams sort of provide instructions to the global mobility leader to complete the public access file. And then it's not clear whether the global mobility leader has enough time or capacity to finalize that public access file electronically. Other teams and other programs will have the legal team compile it. There's a lot of tech out there that can do this automatically, sort of zip up the file and deliver it, and make sure you know where those public access files are being delivered. So that's sort of the first compliance checklist item is identify where you're keeping the public access files and if there are any legacy public access files that may be in paper form. The next step in your sort of compliance quest for LCA is gonna be looking at a LCA or a legacy LCA report. So I think you can kind of put it into sort of buckets of, legacy LCAs, maybe that's you've switched counsels. This is something I'm doing a lot for my clients that we've onboarded. Not only do we do an audit of all files coming in, but we put together a legacy LCA report. My team would not have prepared the LCAs, but we want to make sure that the client has full visibility into their previous LCA filings. And in that LCA report, it's going to summarize the key fields that we need to ensure compliance: location, title of that sponsored position, as well as the prevailing wage. And so those sort of 3 pieces, as well as a purge date. So on a report, the first thing you're gonna look at is, are there any old LCAs that can be purged that you don't need to keep track of? When I mentioned, a paper filed public access file, if you're coming across that, your first question is gonna be, do I still need to retain this? What are my retention requirements? So review those with your immigration counsel if you're not already going to engage immigration counsel to help you with this audit. Your first question is, what can I get rid of and I don't have the retention requirement? Once you've sort of perused that and purged anything that can be purged, on that report, you're going to look at a current status. Maybe this is coming from your HRIS. Hopefully, you have reliable HR data somewhere. And you're going to look at a comparison of what's on your LCA report for the sponsored employees and what's the current state. I think this comes up a lot with remote workforces where the underlying LCA may reflect only a home work site for that remote employee, and that remote employee may not have updated you for their move. And so you're going to want to come up with a strategy of, would you amend the LCA? What is required to amend the LCA when you only have a home work site and that employee moves? So again, not giving legal advice here, but when you're looking at those legacy reports and the current status report, you're flagging if there are any distinctions or differences between what was filed on the LCA and what the current state of that employee's work site and wages. And we're concerned if there are wages outside the wage range on the LCA. We're concerned if there's a new work site. We're concerned if the employee is no longer serving in the role for the underlying LCA. And so once you've sort of identified and flagged the differences, you're going to work with counsel to identify whether this triggers amendments and how to file those amendments to make sure your program and your H-1B and E-3 employees are in compliance with the rules and the LCA rules for their visa statuses. So if you're looking for support on that, We do have LCA reports, LCA legacy reports. If you're looking for what that might look like, ping me on LinkedIn. I can give you a template of, the fields of what an LCA compliance report looks like if you're going to be working through this on your compliance quest. That's it for the business immigration benchmark this week. We hope you're having, again, a great summer and digging into compliance in these summer months, summer projects. We'll catch you next time on the business immigration benchmark.